Good morning, Ms. Hassim. May I request that you please place yourself on record? Oh, your mic.
Good morning, Chairperson and Commissioners. I'm Advocate Khan, representing General Khan.
Good morning, Mr. Khan. Thank you. Yes, Ms. Hassim?
Good morning, Chair. Chair, we have an in-camera application that was made by General Khan's legal representatives. The Commission has answered the application. We oppose the application. I won't make my submissions now. I think it would be appropriate for Mr. Khan to address his submissions in relation to the in-camera application.
Thank you, Ms. Hassim. Yes, Mr. Khan?
Thank you, Chairperson and Commissioners and Ms. Hassan. There are two intertwined issues before you this morning.
Sorry, Mr. Khan. There's something I forgot. Last night I made an arrangement, I even forgot to tell my co-commissioners, with Ms. Bowe about Mr. Nku, that we would formally postpone the hearing of his testimony to tomorrow. I assume, I see I have a laptop here. Ms. Bowe? I'm sorry, Mr. Musigidi. It was Ms. Bowe who contacted me. I'm very sorry about that. Good morning, Mr. Musigidi.
Good morning, Chair. The arrangement is in order, Chair.
Good morning, Mr. Nku.
Good morning, Chair.
Yes, Mr. Musigidi.
Chair will remember that Mr. Nku's testimony was stood down to resume either today or tomorrow. Chair, I wish to report that we are still finalizing Mr. Nku's statement, so we will be in consultation today. And what we are seeking, Chair, is that you stand down his testimony to tomorrow morning. Then we can resume with his evidence then, Chair.
Thank you. Mr. Nku, the hearing of your testimony is postponed to tomorrow. Tomorrow, the 2nd of July, 2026. Do you understand, Mr. Nku?
Thank you, Chair. I do understand.
So you will have to be here tomorrow before 9:30. We will start at 9:30. Understood?
Yes, Chair. Thank you very much.
Thank you very much. Thank you.
Thank you, Chair.
I think we are done with these laptops, at least for now. Thank you. Yes, Mr. Khan.
Thank you, Chairpersons and Commissioners, Ms. Hassan. There are two issues presenting themselves before you this morning for consideration. The one issue, as formulated by the evidence leaders, is the question of the in-camera application. And the second issue, while distinct and pertinent, is intertwined to the first issue. The evidence leaders have indicated that notwithstanding the current circumstances in relation to General Khan, they wish to lead their evidence today due to time constraints. I'm going to address both these issues, if I may.
Just very, very quick, is it today? The leading of the evidence, will that be today? I understood we are hearing the evidence of some other witness today.
Chair, there is another witness who's scheduled, the in-camera witness L, this afternoon.
Yes.
So the directions we would seek would be for the chair to allocate a date to us. And with regard to the current schedule, I think that the soonest time you could hear me on General Khan's evidence is Friday, since we've just postponed Mr. Nku to tomorrow.
Yes.
Thank you.
So if you could make your submissions on the basis that what the evidence leaders are indicating is Friday, Mr. Khan.
Thank you very much,
Thank you,
Chairperson.
thank you.
This is the first that I hear of this change. It might have an impact on what I intend saying to you, because I might want to interact with Ms. Hassam and try and get some direction, and if necessary, postpone what I want to say to Friday morning. It will be a short address, but I might be able to clarify issues in advance with her, thereby saving the Commission some time. The first issue can be disposed of this morning, and it emanates from paragraph 10 of the opposing affidavit that was filed, was it yesterday? Yes. I'll just read the relevant portion in the evidence leaders say the following. The evidence leaders accordingly invite General Khan and his attorneys to reformulate a better focused application having regard to the issues raised in the answering affidavit. Without going into the details of what and what may not be reformulated and what the concerns are, I accept the invitation and we'll do that, given the circumstances that we find ourselves in and the urgency with which the in-camera application was brought. So that disposes of the first issue. As regards the second issue,
Mr. Khan, what is the first issue that you say is now disposed of after you read from the answering affidavit?
that is our General Khan's application for an in-camera hearing, which was delivered on Sunday before the unfortunate incident. So the evidence leaders yesterday delivered an opposing affidavit, but it is a qualified opposing affidavit where they concede that there are potentially certain matters that may be sensitive and requiring considerations of in-camera application. But they, however, raise certain points in relation to the terms of reference and specifically what should be in camera as opposed to a blanket in-camera application. So, reading from what they say in their opposing affidavit, we accept the invitation that we better formulate what it is exactly that we want in camera, because we have made the concession that not everything ought to be in camera. There are other considerations emanating from this as well, which we've communicated to them, and we don't need to detain you with, but there might be a need for IDAC to comment on certain things that we wish to say. So it's a work in progress at this stage, and because of General Khan being indisposed, we believe that we can do a better job and present this application better considered by both legal teams before you.
Will this, constitute or is what is still to be filed a supplemented affidavit, the application remaining the same?
Yes, absolutely.
All right.
Subject to the proviso that despite what is floating around in the media and doesn't bother us too much, that General Khan is actually unconscious, sedated, and we haven't been able to get access to him for purposes of further instructions in relation to this. So obviously the supplementary affidavit will arrive as and when we are able to present it.
Any further submissions? I just want to ask a quick question.
Yeah, there was an invitation for us to present medical evidence, we have now received the J88, which we will immediately make available to our colleagues. And there is a request. Please continue. There is a request by the family members.
Yes, Mr. Khan.
Yeah, it's a redacted J88. There is a request by the family members that I invite, given what is being said in the media and in the social media, and the concerns raised by the police, there's allegations that this is a contrived shooting, etc., and that General Khan is in fact lying relaxed in hospital eating jelly, that we invite the chairperson and or the further commissioners to have access to him in hospital and to speak to his medical attendants and verify and satisfy yourself that he is in fact in an extremely critical situation as set out in the J88.
Morning, Mr. Khan.
Good morning, Commissioner.
It's just not clear to me what you want us to do with the current application. Do you want it to be postponed sine die while you supplement?
Absolutely.
And the idea, as I understand it, is that you are going to specify what you are referring to in prayer 2, because as it currently stands, it's too wide. So the idea is that you will specify it in line with the invitation in paragraph 10 of the answering affidavit.
Absolutely, it's that.
So the current application as it stands will be postponed sine die.
Correct.
And then the second issue, it doesn't affect this application because the application was about Mr. Khan himself giving evidence in camera and not what the evidence leaders intend to do on Friday. But you say you need time to discuss with Advocate Hassim so that you have clarity in terms of what is it exactly they intend to do on Friday.
Yes.
Have I understood you correctly?
Yes, if we are able to come to some agreement on what happens on Friday, great. But if we're not, then we would like to obviously address you further on Friday morning as to how the procedure unfolds.
All right.
Thank you.
By when will this, let me just loosely call it a supplement, by when will that be filed?
Chairperson, Advocate Khan, as I've indicated, is...
General
Khan.
General.
Sorry. This... I noticed yesterday that the media indicated that I'm General Khan's younger brother, which I'm not. So, yes, General Khan. Both my attorney and I have had access to General Khan. He's not verbal at the moment. He is sedated. He's got tubes coming out of his mouth, abdomen. His doctors have restrained the number of visitors that he may receive. I've brought photographic evidence for the commissioners. And again, we invite the commissioners to attend at his hospital to satisfy yourselves as to his condition. He's certainly not a person who's lying in bed, awake, enjoying his hospitalization and able to give us instructions. So, briefly to answer your question, I cannot commit to when this supplementary affidavit will become available. Of course, this supplementary affidavit talks to his ability to testify. So if he's unable to testify, if he's unable to commission a supplementary affidavit, he's most certainly unable to testify. So they go hand in hand.
We as the Commission are not necessarily bound by what the evidence leaders said, which is what you've referred to as an invitation, which you say you accept. Nothing stops us if we were so minded. I'm not saying that we are. But nothing stops us from dismissing the application outright on the basis, for example, of vagueness. And I must tell you outright that I feel that the application is very vague. For example, I have no idea altogether whether what General Khan is asking for is only for evidence relating to the Eratin bust to be aired publicly. So I don't know whether that is what he is saying. All that can be heard publicly is Eratin and nothing more. If that is the case, the affidavit does not explain why everything else is out of bounds in terms of being aired publicly. There's nothing there altogether. For example, let's take what is contained, just one example, the communications between General Khan and Mr. Sayed. Let me not get into the detail of what those say. You know what they say, and they are out there in the public domain. But the point is, looking at those, at face value, those appear to be private communications between Mr. Sayed and General Khan, without an explanation as to why those raise security or intelligence issues or confidential issues. I'm completely at a loss. I'm completely in the dark. So, one, perhaps you should answer the question whether indeed the application is suggesting that all that may be heard publicly is the Eratin bust. Is that so or not?
No, it is not so.
Then
So-
what more then may be heard publicly?
Yes. So, of course, Chairperson, the application must be viewed in its correct context. And part of the context, and I do not wish to detain you more than is necessary, part of the context is that as late as last week, we received something like 370,000 line items of WhatsApp messages.
Yes.
The evidence leaders in their affidavit seem to intimate, well, it's your WhatsApp messages, you should know about it. There are considerations such as the authenticity of the messages, whether they are altered, we don't know. Whether they have been, whether the chain of command has been retained, we don't know. We've invited access, and these are all the events before Sunday night. We've invited supervised access to the devices. That has not been forthcoming. So we have considerations, and my attorney's done a calculation, surprisingly, that if we were to spend 10 seconds reading each WhatsApp message, it'll take us about 200 days to get through all of them. So in that light, we ask for the indulgence that we have the opportunity, and the evidence leaders have, for all intents and purposes, acknowledged this, that we be given the opportunity in the fullness of time to better formulate this application and to allow us the opportunity to place full information before the Commission. Suffice to say, as late as this weekend, we received another 11,000 pages of bank statements with the explanation that, well, it's your bank statement, you should know what's in it. We, of course, need to go through this, and because we are now hamstrung, there is an amount of delay. We ask the Commission, and correctly so you have pointed out, that you are not bound by what the evidence leaders say. We ask you for that indulgence. Given the extraordinary circumstances that we are faced with presently, we hope to be able to move matters forward and to better present ourselves before you. And it's simply an indulgence at this point in time.
What you are addressing now, with the exception of the bank statements about which I've not seen anything in writing, but the rest of what you say, the number of texts, the thousands or even hundreds of thousands of texts, the thousands of pages and so on. If I understood the application correctly, you raise those issues in the context of seeking condonation for the lateness of the application. That has nothing to do with the question that I asked, which is, what is confidential or relates to state security, relates to intelligence? What is it in the application? You have detailed all of the things that you have detailed, and none of that addresses the question that I put to you. I hope you understand. Also, and of importance is that even if you complain about this material that you say was delivered late, General Khan, through your assistance, I assume, has brought an application for an in-camera hearing, stating, as a matter of fact, he doesn't say there's a whole lot of material or stuff that's still outstanding. He has come to this commission asking for an in-camera hearing on the basis of state security, confidentiality, intelligence matters, investigative ways by the intelligence operatives, all of which should not be aired publicly. So he took himself or understood himself to have facts to come to this commission. That has nothing to do with the material you have just placed before us. Because if that was the issue, then he would not have been ready to bring the application. So my point about the application being vague stands.
Yes.
And you would have you have to respond to that if you wish to. Please
Thank you.
do.
So, Chairperson, you will note that this application was brought at a late stage on Sunday evening, whilst all these events were unfolding. But to answer your question, General Khan is not here to testify today, and the commissioners have to unpack what is in the current application. There is room to breathe, to fix up what is currently a lacuna in the application, and I concede that before you. If you were to close the door without offering us a better opportunity in this
But at the very least, Mr. Khan, you should be able to explain the basis on which the application was brought in the first place.
Yes. So,
For example, the application in so many words refers to the relationship between General Khan and Mr. Syed, and I think it's the only example it actually touches on. I may be wrong. So it does refer to that, and all it does is to talk about context and how the intelligence system bears relevance to that relationship. But are we to take General Khan on his word on that? We cannot. We cannot grant the application on his word. There's some context. What context? There's some bearing. What bearing? We are completely in the dark. We cannot grant an application like that. So it's on that basis that I say, why did General Khan come before us? At that stage, he was well. He had not been shot. And by the way, let me place it on record that the Commission has in so many words expressed its words.
and condolences. Thank you, Commissioner.
I've only heard but I'm a third language English speaker. I've only heard condolences used in the context of someone who has passed on. I'm not saying it's not used in the context in which you are using it. But you are quite right. We have, as a commission, expressed those words. But the point I'm making is, at the time this application was crafted and brought, he was well. No question there. So I have difficulty understanding the basis on which the application was brought in the first place. Serious difficulty with that.
Yes.
That there has now been an offer which General Khan, through you, is grabbing, is something else altogether. Was there an application before us in the first place? If there was, on what basis was it brought before us?
Okay. So,
Because I mean, I have said it's vague. I could actually go further and say it's hopeless. From where I'm sitting, it's hopeless.
So, Chairperson, we are faced with the following situation. This application was brought on Sunday. On Monday, the evidence leaders conditionally opposed this application. There isn't even a replying affidavit before you at this stage because of circumstances. Now, the basis, and I don't wish to argue the matter fully, the basis of the claim for an in-camera application is set out under certain headings in the application. The evidence leaders have come back and said it's not sufficient, we want more clarity. That could very well, in the fullness of time, come in the replying affidavit, which should not be new because it talks to the headings. But to answer your question, what's the basis, why at the late stage? And I understand your question. This matter has been unfolding for some time. It is on the back of further evidence that is being presented at the Commission. There are circumstances that are set out in the affidavits in the High Court application. So there are a lot of moving parts in this matter that remain moving. One may look in the crystal ball and say, yes, you should have brought this application at an earlier stage. One may criticize the legal team, but the reality of the matter is that we have...
I am not raising any of those. I'm raising a different point, but please continue with your response.
I am submitting to you, Chairperson and Commissioners, that there would be no prejudice or harm affording this application to become ripe and then considering it as opposed to dismissing it summarily at this stage without a replying affidavit and without a full opportunity to place more information before the Commission. So it's an indulgence that we seek. Your powers are wide, and there we find ourselves.
So do I understand you to be saying you have no answer to my question, because even up to this point you have not answered my question? Do I understand you to be saying you have no answer, and that perhaps everything will become clearer once what you call a replying affidavit has been filed? But as to the basis of bringing the application that is now before us, you are not able to give an answer to the question that I asked. I did not hear a direct answer to that question. I've heard everything else you have said in this regard.
May I have an opportunity?
Yes.
And Chairperson and Commissioners,
Yes.
I'm limited in my ability to go into the individual line items of what's set out in the founding affidavit.
Yes.
Because the evidence leaders yesterday suggested certain reductions before they present these affidavits to the media, inviting them to decide whether the media wants to oppose this application. Of course, if I am to address you on the line items at this point in time, then it frustrates that process. The Commission would have noticed that we have set out certain headings in relation to certain investigations that implicate other people, other events, other transactions. I don't want to go into them at this point in time, but we seek the opportunity to go into them. I've heard what your understanding is. I've heard your criticism of the application, and I really find myself in a position where I don't want to testify. But at the same time, I wish to say that we can better clarify the information for the Commission, and there is an ability to clarify the information.
Just one last point, perhaps, before Commissioner Baloyi raises a point she wants to raise. As a commission, we are not a court of law, but this is a judicial commission of inquiry, and so some of the laws, even procedural matters applicable to courts, may well apply to us as well. Where am I going with this? Are you proposing making out a case in reply, which you would not be able to do if this were a court of law? So are you proposing to make out a case in reply? If so, can you do that?
So I answer that on two bases. The short answer is obviously no. We all know that as lawyers. But making out a case and introducing the facts for the first time in reply is what we would consider making out the case. Further addressing and elucidating what is under the headings that have now been redacted is certainly not making out a new case.
Those, if you say, what you are saying now, you just preface by saying, if you introduce new facts, you would be making out a case in reply, elucidating on points which on their own or in and of themselves do not make out a case, and then you elucidate. Those would still be facts, and those would be facts that make out a case in reply. So I don't quite get the distinction that you are making.
So if I may get to the second submission that I wanted to make, and then I'll come back to the first one that you raised. Of course, there are very limited bases on which I may attack your terms of reference, which are wide in and by themselves.
And
But
you would have to take the president to court in that regard.
But fairness is a central theme. It isn't one that we can get away from, particularly given the current circumstances, where my indulgence lies. Coming back to your question, and I'm certainly not going to discuss the tenets of the law, certainly not with a constitutional court judge and eminent members of my profession, but headings have been set out. General events have been set out that are redacted, and I'm cautious as to what I say in front of the media. There is a criticism of certain things that have been set out in the opposing affidavit, and I can deal with those criticisms without going into something new in a replying affidavit. I can also supplement my founding affidavit under limited circumstances again. So without laboring the point, General Khan is not before you today. I am not seeking to delay this morning's proceedings because his evidence would have been led. His evidence, this portion of the evidence before you is in any event going to be postponed, and that is conceded by the evidence leaders. In those circumstances, we ask you for the leeway to better focus this application and present it before you.
Thank you.
Mr. Khan, you have referred to paragraph 10 of the evidence leader's answering affidavit, and you have read the very last sentence. But that last sentence which you have read should be read with the conclusion of the same affidavit. And paragraph 23.1 of the conclusion says you haven't made out a case. That's what they say. They're not inviting you to improve on this application. They say you haven't made out a case. And then 23.2, they say bring a new application for in camera. That's what they say. So it's not an invitation at paragraph 10 that you should now improve on this application as in supplement or reply. And I think it's important to clarify that our position is very clear at paragraph 23.1. So effectively, they're asking for a dismissal at 23.1, and then 23.2, they say you can bring another application, a better application for in-camera directions. That's I think, a proper way of reading that paragraph 10. But more importantly for me, it is we either now have an application for an in-camera hearing, or we don't. You have an option. You argue your case on the application that you have filed, and you've had the discussion with the chairperson about it. But that is the application that we have in front of us. You either argue that or you withdraw it. You cannot have a holding position, because listening to you, you effectively are asking for this in-camera application to be held in abeyance, so you have a holding position. We don't get to decide, the chair doesn't get to decide, give a ruling on this application, but it's held in abeyance until an unknown time, when you eventually will come back and say, now I'm ready to supplement or to file a replying affidavit. But that cannot be. I think you have only two options. You either argue this application and say, we've made out a case. And on the, because I'm not going to speak to you about you can make a case in the replying affidavit. I think you're fairly conceded to the chairperson that as a matter of procedure or process, you can't do that. So you have pleaded a case in the founding affidavit. It's either good or bad. You stand or fall by it. Your alternative is you withdraw that application and refile a new application whenever you do that, and matters and the prevailing position on the second option would be we don't have an in-camera application until you file a new application. It's that, yeah, I think you can respond to that if you want, but it seems to me that's the position that must prevail.
Thank you for the opportunity to reply. Commissioner, you took me from paragraph 10 to the conclusion, but in fact there are further matters in the affidavit of the evidence leaders that talk to this issue holistically.
You can point me to that
If I may take you to
I've missed them.
paragraph 4.
Yes.
Paragraph 4 is not an unqualified opposition. They say so, it's a qualified opposition. But more importantly, the concession is already made by the evidence leaders in paragraph 4 that some of General Khan's evidence may very well be held in camera.
Yes, no, that's not my debate with you.
Yeah.
What I'm saying to you is read 20, the conclusion. The conclusion is clear that on what the evidence leaders are saying is on this application, you haven't made out a case to be heard in camera. They may hold the view that some of it, some of what he may well be testifying to, given what they know now, because investigations have been done, certain evidence has been collected. So the evidence leaders may well hold that position, that there is some evidence that's going to have to be in camera. But on this application, as it stands, you haven't made out a case. That's why they invite you to reformulate. You can't ignore 23.2 because that will be selective reading. You can't ignore it. In 23.2, they say you have to make a new application. Now dealing with what it is that you identify as in camera. And my proposition to you, what I'm saying to you is, until there is a new application, we have to decide this application, or you withdraw this application and then bring a new application, because that's the invitation they're making to you.
I'm in agreement with you that we cannot read this affidavit as a compartment, and we've got to read it holistically. And you refer me to one portion in addition to paragraph 10. I say that read holistically, the concession is fairly made by the evidence leaders in paragraph 4 and paragraph 5 of their affidavit, where they concede that certain portions of his evidence may have to be led in camera. And they then concede in paragraph 5, the evidence leaders do not dispute that genuinely sensitive information may be appropriately protected. Now, what Commissioner puts to me is an election. Elect whether you are proceeding or elect if you're withdrawing.
Yes.
And I say to the Honorable Commissioner that I do not have a replying affidavit. Presently, I do not have a client that can instruct me further. And I'm asking for an indulgence to get back to the drawing board with my client if and when he becomes available, so that I may better then address the concerns that have been raised by the evidence leaders. I ask that you not close that door on me, given the circumstances, and they are extenuating circumstances. So allow me the opportunity, whether at that stage to withdraw and bring a new application, or at that stage to fairly concede what the evidence leaders want. But at this stage, because of the events of Sunday night, I sit before you with no replying affidavit and without a client able to say to me, do X, Y, and Z. Now, when I'm put to that election that I must withdraw this application without a mandate, I'm then on thin ice.
Yes. Why would it be to close the door to you if this application is decided on what we have in front of us? Why would that preclude you, or how would that preclude you from bringing a new application as invited by the evidence leaders?
The way in which I understand what is said by the evidence leaders, holistically in the affidavit, is come to us, come engage with us, whether it is by affidavit or in person, and let's talk about and discuss what ought to be in camera, because the concession is fairly made that some matters potentially ought to be in camera. I hear you saying, well, why can't that process unfold later and this application be dismissed? My answer to that is one does not seek a duplication of processes before you. One also doesn't wish to create the impression that an in-camera application has been abandoned on the merits of it. And we are live to what is happening both inside and outside this commission.
Yeah, no, Mr. Khan, you can't be asking us to make rulings on the basis of what's happening outside the commission. We've got papers in front of us.
Yes.
Before the incident of Sunday, you prepared an application and you were satisfied this meets the requirements for an in-camera application. You must have been convinced that you will succeed, right? Otherwise, you wouldn't have filed the kind of affidavit that you have filed. So you are confident, you and General Khan, before Sunday, were confident you've made out a case for an in-camera hearing. It doesn't take the evidence leaders to say you have not made out a case for you to say, well, I now need to do a new application, I need to supplement. It shouldn't even get there, right? When the evidence leaders say this application or this founding affidavit on its terms does not make a case for an in-camera hearing, you can't hold on to that and say, therefore, I'm entitled to do a supplementary or to be given an opportunity to consult with my client so that I get more. It doesn't work that way. You stand and fall by your founding affidavit, and as you concede in your replying affidavit, you don't make a case. In ordinary circumstances, you would have been only allowed to introduce new matter that you couldn't have anticipated that comes out of the answering affidavit. Then you would deal it in the replying affidavit. That's not the kind of situation here. What we have here is you have pleaded certain headings. General Khan has pleaded certain headings and says this heading qualifies to be heard in camera. And there's quite a number of them. And the engagement with the chairperson, between you and the chairperson, is to say, well, on those headings, you haven't made a case for an in-camera hearing. That the evidence leaders take that point with you, because that's exactly what they've done. That they take that point with you does not create a door for you to say, well, I need to file another affidavit, and until then, you can't hear this application. This in-camera application. It just doesn't work that way. Effectively, what you are seeking is you seek to hold the hand of the commission in abeyance until eventually you are able to consult and get instructions from General Khan, whenever that will be, because that's effectively what your submissions is. Then we have this floating application, which is not being heard, which is not being decided, because you can't help your circumstances. Your client is in the position that you describe. And so we can't do anything about that part unless you can reach agreement. But in fact, even the agreement hinges on you getting instructions from your client. So we're pretty much in that same space. It's not as if it gets better You know, when we say, if the decision is go and consult with the evidence leaders, you would still say, I need instructions from my clients. And you've described him to be in no position at this point to make instruction, to give instructions. So either way, it doesn't seem like the commission wins. You know, things will roll out in the way that we'll see eventually, but that cannot be. The point I'm making, or I seek to make, is we do have an application before us. If the final determination on this application is that a case has not been made out, then you must lose, or General Khan, the application must be dismissed if a case has not been made out. The evidence leaders have indicated what they consider in the answering affidavit as matter that doesn't require an in-camera hearing. You get the opportunity to address that. You may disagree with that, and that's a matter that will have to be determined. But they've indicated what it is that they consider not to be matter that qualifies for an in-camera hearing. If your application is dismissed and the evidence leaders are allowed to continue, or you agree with them that the matter that they've identified can run without an in-camera hearing, nothing precludes you from bringing a new application that now deals with other matter that you say warrants an in-camera hearing. You may even want to canvass the same topics, but this time with better information that is of assistance to determine that application. It seems to me that's the way that it can only proceed. Otherwise, we're going to be sitting in limbo for an indefinite period. And that does affect the workings of the commission.
If I may have an opportunity to respond and to take an instruction from my attorney. Regarding the observation that the commission will be held in limbo, General Khan is obviously not disposed to tender evidence presently. So the application talks to his evidence. And if he, and rather than put the cart before the horse, if his evidence is not coming, then the issues surrounding the in-camera application for present purposes are moot. So if this application were then to follow at a time when, if and when he is ripe to testify, if we get there, then obviously this application must talk to that set of facts. Currently, this application, I hear you to say, is holding the hand of the commission. I do not understand that aspect because the commission's work continues as it is.
It relates to the evidence of General Khan. That's what I meant. And I thought you would understand. I'm speaking specifically to the evidence of General Khan.
And that affects the scheduling. That affects the scheduling because, for example, there will be no witness on Friday. There will be no witness on Monday. So it affects the scheduling. That's the context in which Commissioner Balo is, amongst others, making the point that she's making.
If I may take the instruction, please. Thank you for the opportunity, Chairperson and Commissioners. Our position is that we don't wish to hamstring the work of the Commission. As regards the evidence of General Khan and what is to unfold, we're told by the evidence leader at this point in time that they will be addressing you on Friday morning. May I have the opportunity till Friday morning to consider my position and then communicate and engage with them? It might very well be that we can limit issues with them, and then we report back to you on Friday morning.
Mr. Khan, if we were in motion court, you would be asking a judge to remove your matter from the roll because the judge would have raised difficulties with your application, and you would be aware that if you were to proceed, it's likely to be dismissed. So the mic is, yeah. So that's where you find yourself, and speaking for myself, I understand your difficulty because you are counsel. You don't have the authority to withdraw or to tender a withdrawal. You would need to take instructions. But it seems to me that the proper thing would be for you to say the application should be removed from your role today, and your attorneys will decide what to do with it. They may very well, give a notice of withdrawal. But you seem to be understanding Commissioner Baloyi's position because none of what she says prevents General Khan from bringing the same application properly motivated. Because even your notice of motion, your prayer too, as it stands, I have serious difficulties with it. So it's not a simple case of just supplementing or filing a replying affidavit. You need to fix your notice of motion as well. So it makes sense to me that the application has to be withdrawn, and if you are so instructed, you file a proper motivated application that deals with the issues that you want to be heard in camera. Because as it stands, those are not there. It's just blanket statements that we do not understand. So with that in mind, maybe without wasting any further time, just tell us what you want to do, and Chair will consider that and we will move forward.
Thank you, Commissioner. I've heard you say that without giving legal advice, a prudent course might be to simply remove the application, and I'll ask that we remove the application from your roll.
Thank you very much. The removal is yours. It's not done by us. So I assume that we must take the application as removed.
Thank you very much.
All right. In the interim, and regarding any concerns General Khan and you, the legal representatives, might have with regard to possible prejudice, I would refer you to paragraph 23.4 at page 33 of the answering affidavit. There, the evidence leaders make a fair point. The evidence, they say, I quote, the evidence leaders will engage General Khan and his legal team on how to present evidence on the remaining topics in a manner which does not compromise confidential crime intelligence information or prejudice the safety of informants or undercover agents. So it's not as if Ms. Hassim intends to, on Friday, just start leading evidence without that engagement having taken place. This means that Ms. Hassim, as all of us actually should, accepts the fact that with an intelligence operative, there should indeed be intelligence-related matters which should not be aired publicly, security-related and even confidential, all of which should not, as I say, be aired publicly. Ms. Hassim understands that, and because of that understanding, she's willing to engage with General Khan, but because you say he is not conscious at the moment, I thought you said, that means Ms. Khan will engage with you, General Khan's legal representatives, to you accepted that, for example, that this application is not saying we should, what should be aired publicly is Eratin only. So you accept that there's more than just that. So that's the ground which will be covered by the engagement between the two sides, as it were. So in a sense, this provides somewhat of a cushion.
Yes, Chairperson, there is some comfort in this statement here.
Yes.
And that is why I prefaced my address to you with my desire to engage with the evidence leaders and see how we can come to some resolution.
Yes. No, thank you. Thank you very much then. This is closed. The application is withdrawn, so this discussion is closed. But, yes. No, I did say we cannot withdraw. There's an issue or two that I wish to address, Mr. Khan. Up to today, we have never had to follow, interact with, pronounce on, or engage with issues that are out there in the media. But this time around, I do wish to raise issues that were in the media. Here's the background. Our spokesperson, Mr. Jeremy Michaels, picked up an interview that was conducted by Ms. Zianda Ngobo, and she was interviewing you. Our spokesperson was quite concerned by some of the things that you said, and he suggested to the commission that a media statement should be issued addressing those issues that concerned him. After discussion within the commission, the view taken was that rather these issues should be raised here in open session with you. I will commence to do just that. At what time did General Khan serve his papers on the commission? It was Sunday night, was it not?
That's correct.
At what time?
My attorney is checking right now.
It is at 4 minutes past 11 on Sunday night, Chair.
4 minutes past 11, yes. And at what time is General Khan supposed to have been shot?
If I may. We do not say with certainty, but it appears to be approximately 11:30.
11:30. Now I want to refer you to a response. We have a transcript of the interview.
Chair, we could provide a copy of that transcript to my learned friend.
Oh, you did?
I'm not
Sorry.
certain when. I don't have it in front
No,
of me.
I'm saying we could provide a copy
all right.
as you addressing
All
these
right.
issues, so he has it in front of him.
Perhaps we should adjourn very briefly, and you can indicate as soon as that has been done. We'll just wait outside here.
It won't be long, Chair, so don't go upstairs.
Sorry?
I said we won't be long, so
No,
don't go
I'm saying
upstairs.
we'll stand outside
Okay.
here.
Thank you.
Let's adjourn.